And that's why I was a bit worried when I heard the sole administrator saying that this is my administration yesterday. The sole administrator does not have any administration. The governor of Rivers State remains Governor FUBARA. But his powers are frozen now, pending when the danger that the proclamation is meant to address is taken care of. So the soldier should be very careful about how he starts talking about his administration. If he's talking about administration, then that may be one of the things that may be used actually to strike down this proclamation. Because if those who are threatening to go to court can establish their locus and they can bring material showing that the man is operating as a governor. For instance, I don't see a sole administrator being able to sign a CFO in that state.
This conversation just with how you would assess this issue against several measures. Number one being the constitutionality of President Bola Ahmed Tinubu's decision. Second, the legal standing of the appointed interim administrator. What legal standing does he have? Is his position constitutionally recognized? And three, the role of the legislature in all of this. Of course, with separation of powers, there are different arms of the government. So what is the role of these different arms of the government, and what is our reality as it pertains to the separation of powers in Nigeria?
Thank you very much, Kashi. It's a pleasure to be with you this morning. I would like to start with a word of hope and word of salutation to the drafters of the Nigerian Constitution. If you do not relate back to where we were in 1962, nobody will have a better appreciation of Section 305 of the 1999 Constitution. And so, in the 62 Constitution, which was tested, it led to an imbroglio because the power to declare emergency was vested in the parliament, and the parliament was required to have two-thirds majority to declare emergency. Now, the experience was that when that happened, the national parliament declared emergency and enacted legislation to guide the administrator of the state of emergency in a divided parliament. And that led to all the other things that eventually accounted for the collapse of the First Republic. The wise men who drove the 1979 Constitution that was recalibrated in 1999 learned from that and decided to diffuse powers with regards to declaration of state of emergency between the three arms of government. Rather than have the parliament subjected to democratic debate before declaring emergency, they gave the initial trigger power to the president under the 1999 Constitution. But that power is a power that is exercisable for a limited period in order for the other arm of government, which is legislature, to review and then share the intelligence to determine whether there was a good reason to declare a state of emergency. So in 305, the president, once is satisfied, based on relevant consideration, including security reports, that a situation has arisen to warrant his proclamation of emergency either in the whole country, in a part of the country, or a part of a state, will then issue a proclamation that will be gazetted. But you can only do that and enjoy the exercise of that power for not more than 2 days if Parliament was in session. So you can see the beauty and the wisdom behind 305. So if a president did not do his homework and just assume that Parliament will see things his way, he would disgrace himself within 48 hours, because after 48 hours, if he doesn't get approval of Parliament, that proclamation will automatically terminate. And that will diminish him. So the idea behind distributing this power is to ensure that great consideration goes into that weighty decision. And you assume that if you are going to need the parliament to have two-thirds majority of all their members agree with you to take certain steps that will more or less suspend certain provisions of the law, you have to do your homework. And I think this has worked out perfectly this time around. Contrary to what a lot of people are saying, people do not realize that today now, it is not the president's order that's in force now. It is the approval that Parliament gave that order by two-thirds of all parliamentarians in the Senate and in the House of Reps. Now, people have forgotten that there was a case in 2003, which is the case of National Assembly as a president, where the issue of special majority to certain decision of Parliament was considered. And the Court of Appeal in that case held that for two-thirds threshold to take decision of Parliament, it is not by simple majority. And they specifically stated that for the House, what they would need is 240 of the 360 members, and for the Senate, 73 out of 109. People have forgotten that this has been determined long ago, and the special majority must be majority of all members. So I believe that what has happened so far, the executive has done his own part, the parliament has done its own. What is now left, if need be, is for the judiciary to intervene. And the judiciary has a policy of respecting each of the other arms of government in their own spheres of influence. The The decision whether to declare emergency is not a judicial decision, it's a political decision. That's why you can subject it to vote. If the country is going to collapse, you can't go to God to get an injunction against war. You can't go to God an injunction against a breakdown of law and order. So it's an executive function that will be triggered. So I believe that reason has prevailed and the constitution has worked perfectly as intended in this instance. Whether the decision to now declare emergency is an abuse of power or not is a matter for the court, if so invited, to determine.
All right, SAN,
is with regards to the declaration of emergency.
Okay, I hear you loud and clear, and I get your point as to the procedure that was taken and how the affirmation from the National Assembly now means that it has somewhat shielded the president from direct attack. But a lot of people may not agree with you. A lot of people will say that for you personally, you said that the Constitution has acted, has played out as intended. But then people will say that what happened in both houses, the red and the green chamber, will that pass, in your own opinion, for what the framers of the Constitution actually intended? In the House, it was a vote voice. And people are saying that you can't determine 2/3 of the House by vote voice. And that it would have been a lot better if people knew how each of the parliamentarians, each of the House of Reps members, and each of the senators voted. For the Senate, they even had to go into a closed-door session. We didn't see much of robust discussion, and therefore people feel that it was an acquired endorsement from the National Assembly. What are your thoughts on that? And then secondly, when you say that it's now left for the court to interpret, what do you say to those who say, yes, the president may have the powers under Section 305 of the Constitution to declare state of emergency if certain conditions are met. But then does he have the power to appoint either an administrator or a sole administrator or even an head of interim government for that particular state, given the fact that the Constitution is clear as to how a governor can be removed? So is a suspension of a governor, as the president has done, constitutional in your own opinion?
Thank you very much. Let me address the first. The first is with regards to the procedure adopted by the Parliament to approve the proclamation. And that's why I started the authority of the National Assembly and Federal Republic, the President, in 2003. I would be surprised if, upon a challenge in court, and it is established that the procedure followed did not establish the required quorum. The required quorum to approve the President's proclamation is 2/3 at the minimum of the Senate and House of Reps. And I believe that, though internal affair of the Parliament, if evidence is produced to show that the Parliament did not have the required quorum of at least 2/3 of the House of Reps and 2/3 of Senate, it is possible to strike down the proclamation. So those who are going to court will they have their work cut out. How do they establish the quorum? Because it's an official function. And Parliament will then be the one to provide to the court the register and attendance of members. Once they have 2/3, you already assume they have a quorum. But whether the entirety of the 2/3 voted, that's another issue. So I don't want to comment too much on, but I know that because the requirements are all members, that's what the Constitution says. But the purpose of approving a proclamation is 2/3 of all members of both chambers that should take that decision. 2/3 of all members mean at the minimum there must be at least 2/3 of their.
Yeah, but in taking the decision, SAN, in taking the decision, will a vote voice suffice in taking that decision?
Well, a vote voice may suffice because Parliament has the prerogative to determine the manner in which they decide their matters. But if you are able to show, I think the only chance of voiding that procedure is to show that not up to 2/3 members sat in both chambers. If you cannot show that, and they can show that 2/3 of members were in attendance, and they all endorse the decision, it's for the Parliament to decide what mode they will adopt, as at now in Nigeria, to take a decision, whether by voice vote or by a division. If they don't take that and decide to go by vote, you will have an uphill task to show that not all members supported. As it is today, you can as well assume that the decision to approve was unanimous until otherwise shown in the court of law. That's for that. Now, on the question whether the president can suspend a governor, the president can suspend a governor who is the source of threat to law and order within a state. Because what the Constitution has done is in Section 5, Subsection 3, people have not read this Section 5, Subsection 3 of the Constitution, that the executive power of a governor of a state shall be exercised in such a way as not to impede or prejudice the exercise of the federal power. Where a governor, as appeared to be the case in Rivers, given the judgment of Supreme Court saying that there is no government in Rivers State because the two arms of government were no longer functioning as required by law, the president does not require much more than that. Now, there's a difference between law and order and security. Where the conduct of governance is in breach of law and order, even if there's no breach of security, it portends a big danger. For instance, transactions have been going on for the past 1.5 years in Rivers. Appropriation was not done. Contracts were awarded. Government was committed. If at the end of the day, the determination of whether government was functioning legally were to go against the state, what happens to all those decisions that will have been taken in the last 1.5 years? It's a serious matter. Now, in addition to that, the president cited the question of threat to federal assets. It's one of the conditions under which president, even without invitation by a governor of a state, can intervene and declare a state of emergency in a state if the federal assets in that state are at risk, imminent risk. Now, in this case, there was cited the case of pipeline, whatever going on, being bombed and all the rest. What they mean by federal asset in Nigeria, if you understand it, in Nigeria, really, the asset of federal government in any state now is about natural resources, really, apart from physical building. And if you are talking about Nigeria's mainstay of the economy is oil and gas, if there is a threat of pipeline being blown up, whatever, that is a federal asset being threatened. And that's the whole idea of resource control, because these assets are vested in federal government as against in the hands of those who are supposed to be the natural owners. So if there is such a threat, the president can intervene. Now, it does not require the president to suspend a governor. If the threat in a state actually is a threat that is meant to overwhelm the government of the state, the president needs the government of the state to actually contain it. But where the threat itself is coming from the government of the state that should collaborate with the federal government to address the threat, then that is the first source of threat that should be managed. So the president cannot remove a governor, but he can freeze his executive powers. So suspension is a freezing action, not a remover. Thirdly, you ask whether the president can appoint the sole administrator. Now, people have been looking at the Constitution and they are saying they are looking at 188, he didn't talk about. Now, go and look at Section 5, Subsection 1 of the Constitution in terms of how the president carries out his functions. And also go and look at Section 318 in terms of what is called power, what is function, what is public service, and Section 318(4), which says that to interpret the Constitution, you have to have recourse to the Interpretation Act. That is inside the Constitution. So it's not just we are merely reading section of the Constitution. You have to look at how is that Constitution to be interpreted based on Interpretation Act. Interpretation Act says that where power is given, then functions and obligations and responsibilities and benefit go with it. And if a president, if you look at definition of public service of the Federation, it includes any person who is given capacity to act on behalf of the government. So the president's appointment of sole administrator is not to replace the governor. It's to execute his executive power in the state for the purpose of addressing the question of breakdown of law and order. So, and that's why I was a bit worried when I heard the sole administrator saying that this is my administration yesterday. The sole administrator does not have any administration. The governor of Rivers State remains Governor FUBARA. But his powers are frozen now, pending when the danger that the proclamation is meant to address is taken care of. So so should be very careful about how he's talking about his administration. If he's talking about administration, then that may be one of the things that may be used actually to strike down this proclamation. Because if those who are threatening to go to court can establish their locus and they can bring material showing that the man is operating as a governor. For instance, I don't see a sole administrator being able to sign a CFO in that state. That's the function constitutionally vested in the governor of a state, and that's has nothing to do with law and order. All powers that will be exercised by the sole administrator must be related to addressing the challenge which led to his appointment. He cannot include acting and appointing commissioners as if we are in the normal course of event. It's an extraordinary situation, and his appointment is simply to address that extraordinary challenge.
Will it? Sorry, Kachi, just quick one. Will that function include spending the federal allocation of the state that was suspended under FUBARA, but has now been released to him?
Yes, that is very correct. It will include it, because the order of the Supreme Court was that the governor could not spend money without appropriation. In an emergency in which there is an extraordinary intervention by the federal government in terms of the president appointing a delegatee of his authority, the funds of the state is like commandeering asset in a war situation. I'm sure you remember during the COVID era, even President Trump commandeered a lot of assets, even took over factory and said they should be distributing. In a situation of emergency, ordinary emergency, the fund of the state is available for the purpose of running the affairs of the state. He is not operating as, that's why I said they must be careful. If he considers himself a governor, then he would need appropriation. Then he would then need to go to National Assembly in the meantime to get appropriation. But it's not a governor. It's just a delegating of the power of the federal executive authority that has taken over affairs in the state to address the challenge. So the federal government can release funds of the state to him to address that challenge. I mean, the same reason why police is not under the state control. State governments provide vehicles, support police operation security in their state. So as at now, for the proper functioning of the state, salaries of workers have to be paid. The normal functioning of government institutions must continue. So it's only in that respect that he can do it. Don't forget, however, that he's supposed to prepare regulations which federal executives will approve and which probably the National Assembly can intervene in terms of how he goes about this. I don't think he's going to be doing it in an arbitrary version. And I listened to some of his pronouncements yesterday. He appreciates the duty of accountability.
Okay.